Welcome to Settlement Agreement Lawyers, the UK's dedicated service for fast, expert advice on employment settlement agreements and workplace disputes. If you've resigned because of how you were treated at work, or you're considering resigning, this short video will help you understand what constructive dismissal is and why legal advice is important before you take any further steps. What is constructive dismissal? Constructive dismissal occurs when you resign because your employer has fundamentally breached your contract of employment. In simple terms, your employer's behaviour leaves you feeling that you have no reasonable choice but to resign. Although you resign voluntarily, the law may treat this as a dismissal by your employer. Common examples of constructive dismissal. Constructive dismissal can arise from situations such as persistent bullying or harassment, sudden and unreasonable changes to your role or pay, failure to deal properly with grievances, breach of trust and confidence, unsafe or hostile working conditions. The behaviour must usually be serious, ongoing, or a final significant incident, and timing is crucial. Important things to know. To bring a constructive dismissal claim, you will usually need at least 2 years continuous service, to resign promptly after the breach, evidence showing why you could not continue working. Resigning too early or too late can seriously affect your legal position. How settlement agreements fit in. Many constructive dismissal situations are resolved through a settlement agreement. An employer may offer compensation in return for you agreeing not to bring a tribunal claim. Signing a settlement agreement means giving up your right to pursue future legal action, which is why independent legal advice is essential. Why legal advice is essential? Constructive dismissal claims are complex and high risk. Independent legal advice helps you understand whether your situation may amount to constructive dismissal, the strength of your position, whether the settlement offer is fair, what rights you're giving up before signing, what we'll review during your appointment. During your advice call, we'll look at the events leading up to your resignation, any grievances raised and how they were handled, the terms of any settlement agreement offered, compensation, references, and confidentiality clauses, and whether there is scope to negotiate improved terms. Let's look at an example together. Take Sophie. After repeated concerns about her workload and treatment were ignored, she felt forced to resign. Her employer later offered a settlement agreement. After speaking with us, Sophie understood her legal position and negotiated a stronger settlement before signing. How to get started? Getting started is simple. Upload your documents at settlementagreementlawyers.co.uk and book your appointment. In most cases, your employer will cover our legal fees, so there's no cost to you. Constructive dismissal is a serious and often stressful situation. We're here to ensure you understand your rights, your options, and any agreement you're being asked to sign. Visit settlementagreementlawyers.co.uk to get started.